Welcome to another edition of Dad's Divorce Live. I'm Matt Allen, editor of DadsDivorce.com. Today we're joined by two guests. Mike Doherty, who's with me in studio, is the chairman and co-founder of the Children's Rights Council of Illinois, which advocates for shared parenting. And joining us on the phone from Chicago is sitting judge Michelle Lawrence, who is also the author of the book, The Good Karma Divorce. Now, both Mike and Michelle are well apprised of the dynamics of the many underlying issues with non-custodial parents and the court systems. So I'm going to turn over the conversation to the two experts. So Mike and Michelle, take it over.
Judge Lawrence, good to hear from you again.
Oh, it's great to talk to you, always.
Well, you and I have addressed some issues in the past. Our good friend Kurt Muller had a radio show last year, and I called in and challenged you over some things. And then I brought you back as a guest in April, and we talked again. And of course, you talked about your book, The Good Karma Divorce, which is a wonderful book. I recommend everybody to get a copy of it and read it if you're going through a divorce or thinking of divorce or dealing with the aftermath. And you've got some great and wonderful advice in there for people, Michelle, and I don't want to detract from that. However, you know, our advocacy work oftentimes tries to look for ways to improve the system so that we can provide a greater incentive for these divorcing parents to do the right thing and for putting the kids first.
Right. And what are some of your incentives?
One of them would be that to not create what we see as a perverse incentive where if one parent is obstructive or just wants to kind of throw a monkey wrench into the process, there's a good, if they feel they have the upper hand, then there's a chance they're going to walk away with monopoly power for a long time over the other parent by dint of having more or less possession of the children. That would be the opposite of shared parenting, that the other parent will just get it every other weekend because we have photocopies of that being a county protocol in some of our Illinois counties.
You know, since we've spoken and since I've become so involved in what you're doing and what a lot of organizations have been doing, I've been working on a protocol order that has two tiers to it. One of them is the regular visitation. The second tier would be a built-in system for what happens if people miss their visits and what happens if there's 3 missed visits. For example, let's say you have a father who's trying to visit three times in a row. The children are told to him that he's sick. If that happens, then tier 2 of the order kicks in, which is automatic makeup at his convenience, the right to pick a family therapist immediately, all this stuff without having to go to court.
Right.
By the time, and you know this, by the time you get to court, it could be months before it gets before a judge and you haven't seen your kids. So I'd like to see something implemented. If somebody does, a certain recipe of violations, that a whole new thing, including attorney's fees and things like that, kick in automatically.
Very good. I love the fact that you're thinking outside the box and that you have that sort of advocacy leaning. I know you can't be an advocate as a judge, but you can certainly help suggest better public policy, and that's great that you're coming up with some things like that. What about on the parenting time issue? You know this has been hotly debated deliberated over within the Family Law Study Committee. Our Children's Rights Council board has attended almost every one of their meetings for 2.5 years, and we watched the deliberations on this, Michelle, the back and forth over parenting time, and it seems like the compelling argument was made, or the testimony there was that we really should have approximately a presumption of approximately 1/3 parenting time for fit, caring, accessible parents as a minimum for either parent. What do you think about that?
Well, I think you were there the day that I made my views pretty well known.
Yes.
Weren't you there that day?
Yes, I was.
I've been there a couple of times.
Yes.
But I'll tell you right now so that all the listeners know. When people come into my courtroom, and so that the listeners know, I'm what's called a trial judge, which is the end of the line. It's not the preliminary stuff. It's what happens in those cases where people can't agree on anything and they're going to trial. So when they come in, people who are in fear of not having access to their children are terrified and have been terrified for some time. And people's answer to terror is usually anger and defensiveness. So if it was a foregone conclusion that the non-custodial of the shared parent had a third of the time, people wouldn't feel the need to fight like they do.
Precisely.
And when people feel the need to fight like they do, they're adults. They can handle it. Yes, it's a shame. Yes, attorneys, can profit because people want the fight. But the truth is the children are destroyed by the parents fighting.
Yes.
So I think it would so much help the children by bringing down the acrimony between the parents, because they come in before me and they think they have to arm wrestle for every single day out of the 31 days.
Yes.
And if this was not part of the recipe, everything would be different.
Thank you. That's exactly what our organization believes, and it would reduce.
And Mike, having said that, because I'm a judge, I have to say everything depends upon the facts.
Yes.
But as
sure.
a philosophy,
Yes.
I think that's one worth looking at.
I've asked a judge, a GAL, and an attorney, all very respected in Illinois, just for their private opinion, that if we had a more of a presumption of approximately 1/3, what would happen? And they all agreed. They found it quite likely that we would see a significant decrease in the amount of litigation, because it wouldn't not be all the cases, but they would go for that reason. There would be plenty of litigation over other things, right? Over bifurcating retirement accounts, things that don't involve the children's time with the parents. But the litigation, therefore the conflict over the parents' time with the children, there would be a lot of those cases would never end up in court, because the person say, well, 1/3, that's I can maintain my relationship on that. I can have my parental bond.
And you can, because it's close to 3 days.
Absolutely.
You can maintain it
I agree.
rather than 4 days once a month.
Exactly. Or
You
just
can
or just
imagine-
weekends.
I don't blame anyone who fights over that paradigm,
Right.
because it's frightening for the person who's only going to have the 4 days.
Absolutely.
And then the Wednesdays for dinner.
Yeah, it's like you are
But
you are losing your child.
There is a trend towards expanding visitation for the non-custodial.
I agree.
But the trend is really set by those people who have the funds to fight for it. I'm sorry to say that, but we have a template mentality. Well, every other weekend, Wednesdays, every other, and in the judiciary, this is like, well, this is what we do. So you really do need to think out of the box. And the people that get the judges to think out of the box are the ones who really insist on more.
That's right.
And they're changing. The people who could fund it are changing it for the better,
Yes.
for everybody in a sense.
But sort of like one person at a time coming out of the foxhole who can afford it. And like you say, there's a Boston Globe article, and a reporter there said it was a badge that you had shared parenting, that you were upper income, because you could afford the best attorney, which you needed, and to subpoena witnesses and have a hearing in order to get shared parenting. And that leaves about 80% of those non-resident parents out of the running. Michelle, always a pleasure to have you and to talk to you. And Good Karma Divorce book, I hope more people are reading it and getting some good ideas out of it.
Well, little by little, people are starting to understand, Mike, that it's not, the message is, let's not hold hands, and let's make sure you're very nice and turn the other cheek no matter what happens. It is like completely not that. It's about how to unhook from being reactionary when somebody else does something wrong, how to find your own way to find strength. Because when you're reactionary and angry, you lose strength. And you lose strength to be a good advocate for yourself. You don't get what you want in court when you're angry. It's the opposite. It's about how to get what you need for yourself and for your family with different tools that'll benefit you now and going future.
Thank you for taking time out of your busy schedule to join Mike and I.
It's wonderful to talk to you, and I look forward to talking to you in the future.
That was Judge Michelle Lawrence. This is Mike Doherty, the co-founder and chairman of the Children's Rights Council. That'll do it for this edition of Dad's Divorce Live. I'm Matt Allen, editor of DadsDivorce.com.